When Senator Kennedy cornered Attorney General Pam Bondi about DOJ surveillance of 8 sitting U.S. senators, her evasive responses revealed something deeply troubling about how far the Justice Department had strayed from constitutional boundaries. What unfolded wasn't just political theater, it was a constitutional crisis hiding in plain sight, where phone records of elected officials were seized without the legal safeguards that protect democracy itself.
They have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, well, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes. I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States attorney.
I know they do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, they better have a damn good reason. Right? Right?
Senator, I can't talk about the facts of this particular case.
This is just a hypothetical.
In general, hypothetically, Senator, maybe they didn't recognize any of the names of the 8 sitting United States senators.
Hypothetically.
That was a joke.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for these
Senator,
8?
Senator, I can't discuss anything regarding this.
You can't even tell me if you have copies?
I can't discuss any of this.
All right, when are you going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator. This
but
was
let's
just
assume
brought to light
if
by
there is a
Director
pending investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushed back from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here. If I were your special counsel and you had appointed me and I wanted to get the records of a sitting United States senator, is that something you would expect me to tell you as Attorney General of the United States?
They better have.
Yeah.
And
do we know in this instance of the 8 sitting United States senators if they told Attorney General Garland?
Senator, I just learned about this very recently, as did Director Patel, and we cannot discuss the details. I don't know many of the details.
Well, maybe we ought to get Attorney General Garland here. Do you know if the special counsel told FBI Director Wray? Is that something? Let me put it another way. If I were your special counsel and you were the director of the FBI, and I'm trying to get the phone records of a sitting United States senator, did I mention it was a sitting United States senator? Is that something that you would expect me to tell you as director of the FBI?
In general, I would believe the FBI would help execute the subpoenas.
Yeah.
To the businesses.
Okay, I want to switch to another subject in the 12 minutes that I have left, since everybody else got to go over. I've got to ask you about this, General. Secretary Howard Lutnick on October 1 gave an interview to the New York Post about Mr. Epstein. And he described Mr. Epstein as, quote, the greatest blackmailer ever, close quote. Have you reviewed that transcript of that interview?
I have not reviewed the transcript, but I saw the clip of it.
Okay. It appears that Secretary Lutnick was Mr. Epstein's next door neighbor. In fact, their townhomes shared a wall. And the reporter that was talking to Mr. Lutnick, she asked how other prominent men could have been associated with Epstein when Mr. Lutnick could immediately sense that he was a, quote, pervert. And then Secretary Lutnick said, or rather the reporter said, did they see it and ignore it? Do you remember that from the interview?
I do.
And Commerce Secretary Lutnick said, no, they participated. And then Commerce Secretary Lutnick goes on to say, quote, that's what his MO was. You know, get a massage, get a massage. And what happened in that massage room, I assume, was a video. This guy was the greatest blackmailer ever, blackmailed people. That's how he had money, end quote. Is that true?
Senator, as our July memo said, we did not uncover evidence. This case has gone through 3 administrations, as well as former U.S. Attorney Alex Acosta.
I know that, Pam. But have you interviewed Secretary Lutnick?
No, Senator.
Do you plan to?
If he wants to talk to the FBI or the FBI wants to talk to him, that is more than on.
Don't you think you ought to talk to him after this interview?
Senator, if Howard Lutnick wants to speak to the FBI and if Director Patel wants to speak to Howard Lutnick, absolutely.
Okay. Maybe we ought to get Mr. Lutnick in here too, Mr. Chairman.
Senator Booker.
Thank you. Thank you, Mr. Chairman.
What Senator Kennedy did in his methodical questioning of Attorney General Pam Bondi wasn't just congressional oversight. It was a masterclass in exposing how constitutional protections can be quietly dismantled through procedural shortcuts. Kennedy walked Bondi through a hypothetical scenario that mirrored exactly what happened to 8 sitting U.S. senators, forcing her to acknowledge each legal safeguard that should have protected them. The exchange reveals 3 critical breakdowns in our justice system. First, the concept of probable cause for surveilling elected officials. Kennedy established that obtaining phone records of a sitting senator requires showing a judge that you believe a crime was committed or that the senator was part of a criminal conspiracy. This isn't bureaucratic red tape, it's a constitutional firewall that prevents the executive branch from fishing through the communications of legislators who might oppose them. Second, Kennedy exposed how telecommunication companies abdicated their legal responsibility. Phone companies like AT&T have both the right and the obligation to challenge subpoenas targeting high-profile individuals, especially senators. Their general counsels should have filed motions to quash protecting both their companies from civil liability and the constitutional separation of powers. Instead, they simply complied, creating a dangerous precedent where private companies become willing participants in potential constitutional violation. Third, Bondi's repeated claims that she cannot discuss details reveals the weaponization of investigative secrecy. While ongoing investigations do require confidentiality, using that shield to avoid accountability for past constitutional violations transforms legitimate prosecutorial discretion into a tool for avoiding oversight. When Kennedy pressed whether Attorney General Garland or FBI Director Wray were informed about surveilling senators, Bondi's evasions suggested a deliberate chain of deniability. The Epstein angle Kennedy introduced amplifies these concerns. When Commerce Secretary Lutnick publicly described Epstein as the greatest blackmailer ever and detailed his methods, it became relevant evidence that the Justice Department should investigate. Bondi's refusal to commit to interviewing Lutnick demonstrates selective enforcement, pursuing some leads aggressively while ignoring others that might implicate powerful figures. Kennedy's questioning technique was surgical because he forced Bondi to confirm each legal principle before revealing how it is violated. By the time he finished, she had acknowledged that proper procedures require probable cause, judicial oversight, and notification of senior officials, none of which appeared to happen with the 8 senators. This exchange matters because it exposes how constitutional protections erode through administrative convenience, rather than dramatic confrontations. When the Justice Department can secretly surveil senators without following established protocols, and when the current leadership claims ignorance while refusing to investigate, we're witnessing the quiet transformation of law enforcement into a political weapon. The real danger isn't what happened to those 8 senators. It's the precedent that such surveillance can occur without consequences, oversight, or even acknowledgement that constitutional boundaries were crossed.